the Nyaya Shastra short certificate course on legal drafting and pleading. We are honored to have with us Advocate Stuti Bhandari ma'am, advocate at Dehradun District Court and High Court, and Assistant Professor of Law at Drafting University, with diverse experience in legal drafting and pleading. Ma'am, we welcome you and kindly request you to begin the class.
Thank you, Angika, for the warm welcome. So let me start with today's class. So basically, when we talk about legal drafting and conveyancing and pleading, so this is basically one of the most essential traits that you should have as an advocate. So most of you might have also studied this as a subject in your 5-year LL.B or your 3-year LL.B. It is one of the, according to the BCI regulations, it is one of the compulsory subjects. Now in this class, as I have been given the syllabus, so you will be doing a variety of drafts. Now first of all, I would like to tell you how we would go about the class. What would be the plan of the class or plan of action rather. So first of all, in today's class, this is an introductory class. So in today's class, we would have the basics, that what is a legal drafting, how is a legal drafting done, what is the what are the essentials of legal drafting, conveyancing, pleading. Then we will start with the civil part. So many of you might have interned in the district courts or the high courts or supreme court. So basically, whatever we are doing, most of the work is there in the district court. So we will start with two parts. One is the civil part. So civil part starts with the institution of claim. The criminal part starts when an FIR is registered. So हम दोनों cover करेंगे. So in today's class, we would firstly start with the civil part, and before that also we need to have an introduction of what legal drafting is. And in every class, what we will do is firstly we would have a theory session, like for 5-10 minutes. For example, if you are doing plaint, you might be knowing that plaint lies in order 7 of civil procedure code. So we would do a bit of order 7, that what are the essentials which are mentioned in order 7 of a plaint. Then I would show you a draft, sample draft. I will tell you the intricacies and nitty-gritties of what a plaint should have, what is the essentials of a plaint. And then technically I don't think you to have a WhatsApp group dedicated to this program. So probably here only I can share a problem with you, a draft problem. Then in the next class you can bring those drafts, or if you have any problem and query in drafting those drafts, you can come to me, or I can randomly point out any person to show these drafts. Because drafting again requires you to practice it on a day-to-day basis. It is not something which is theoretical. Because ये आपका आपने सुना भी होगा, या अगर आपका कोर्स स्ट्रक्चर आपने कभी देखा हो ना लॉ का, so it comes in the clinical part. Now without much further ado, let me start with the essentials of legal drafting. So today what we will cover is what is legal drafting, what is pleading, what is conveyancing, and what are the essentials of these. And then we will do order 6, which gives the basics of pleading, and order 7, which gives the basics of pleading. Then tomorrow we will discuss the practical aspect of this. All of the things that we are studying, we will I'll share some sample drafts with you, and you can just scrutinize those and then let me know if you have any doubts. Let me share my screen with you. Also, I don't know that if all of you might have studied B.N.S.S or CrPC, because B.N.S.S and CrPC, they will play because since they are procedural laws. So whatever order section I am telling you or teaching you in the class, kindly go back and revise those, so that in the next class or later on, whenever you are revising and making or drafting something, an assignment that I have given you, you have a clarity on how it is done. Now, basically, today we will start with the introduction. So, we are covering three basic points here. If you can see, legal drafting, conveyancing, and pleading. Now, legal drafting is the broad genus in which conveyancing and pleading lie, which means आपके जो ये है ये सब species है जो conveyancing और pleading है, these are sub species of the word legal drafting. So drafting is anything that you are legally formulating and legally expressing. वो आपका legal drafting में आ गया, that you are formulating, putting out there in a legal manner which has been practiced since time immemorial. अब आप कोई भी चीज ड्राफ्ट कर रहे हो उसको लीगल ड्राफ्टिंग में लाते हैं, उसके अंदर देयर आर टू बेसिक इंग्रेडिएंट्स जिसमें बहुत ज्यादा ड्राफ्ट होता है, कन्वेंसिंग. So conveyancing basically covers whenever someone is transferring an immovable property to any person. तो कैसे कैसे ट्रांसफर कर सकते हैं? अगर मेरे पास एक पीस ऑफ लैंड है तो मैं कैसे कैसे वो लैंड ट्रांसफर कर सकती हूँ? मैं उसे बेच सकती हूँ. आई कैन सेल इट थ्रू अ सेल डीड. आई कैन गिफ्ट इट टू समवन थ्रू अ गिफ्ट डीड. आई कैन मेक अ विल ऑफ द सेम थ्रू अ विल डीड. एंड देन इसमें आपकी कई ऐसी चीजें भी आती है, लाइक पावर ऑफ अटॉर्नी ड्राफ्ट करना, एंड special power of attorney, general power of attorney, agreement to sell, then mortgage deed, then your rent agreement. तो ये सब हमारा conveyancing में करेंगे. And pleading basically as per the definition which is given in the civil procedure code, pleading में आपकी दो चीजें आती हैं, plain and written statement. तो आज हम pleading को basically emphasize करेंगे, but before that we will have an overview of the entire process ताकि आप लोगों के लिए क्लैरिटी हो जाए कि ड्राफ्ट तो बहुत कुछ होता है. आपने एसेज भी लिखे होंगे बचपन में, यू माइट हैव ड्राफ्टेड एसेज, लीगल नोटिसेस भी ड्राफ्ट करते हो, बट लीगल ड्राफ्टिंग ऑफ प्लीडिंग, इसमें क्या डिफरेंस है? ये क्योंकि देखो, अगर आप लीगल नोटिस, व्हेन यू आर सेंडिंग अ लीगल नोटिस टू समवन, वन सेकंड, आई थिंक इज देयर अ क्वेश्चन? Okay, good evening. So also, I do not know, like because since Nyaya Shastra is a channel which is there throughout India, so I don't know if you are comfortable with English, Hindi. If someone has any problem in understanding Hindi, please let me know. Okay, sure. Okay, I'll explain it in English. This is what I was saying because it is a pan India channel. So yeah, I'll have a conversation in English. But if someone has a problem in understanding in English and they want me to repeat it, you can also let me know. Okay. So now coming to the firstly the definitions. Okay, so today is just the static part where we will cover the laws. So what do you understand by legal drafting? Basically, as I told you, you are preparing legal documents. It can be a pleading, it can be a plaint, it can be a divorce petition, it can be a sale deed. Any legal document which you prepare with precision, clarity, and legal enforceability. What do you understand by the word precision? Can anyone tell me? Precision is basically when you are exactly explaining the material facts to the court. You are not unnecessarily telling the court XYZ, the facts which are not required. So you are just explaining with clarity and with precisely the points which are, making you entitled to your relief. That is there in the definition of precision. And then clarity, they should be clear. And lastly, legal enforceability. I cannot make a legal document without knowing the law. For example, if I am drafting a divorce petition for my client, I should know what the grounds of divorce are. I should know where the divorce petition is instituted, the jurisdiction, which court holds the jurisdiction. So your document should be legally enforceable. Because if there is any legal lacuna in your document, then there is no point of having such legal drafts. It should be legally sound and enforceable. Second, coming to the subspecies of legal drafting, which is conveyancing. So as I said, most of the conveyancing deeds, like mortgage deed, lease deed, XYZ, as I told you, there are a lot of them, etc. So they basically create a right, they transfer that right to the other person. So if I have a property, I'll create a right in that property and I'll transfer it to the other person. If it is a sale deed, I will do it in exchange of the money, the sale price. If it is a gift deed, I'll do it for free because you know that gift it does not require any consideration. If it is a mortgage deed, then again I will have a price which would be there fixed in the mortgage deed, that whatever consideration I am taking for the mortgage which has happened. Now coming to pleading. Pleading basically as per order 6 covers only two things, which is plaint written by the plaintiff and written statement by the defendant. Now let me give you a brief idea. This has nowhere been mentioned in the PPT. So you can either note it down and listen to it a bit carefully, though it is not a part of drafting. But are you aware of the procedures or steps which are there in a legal civil suit? Can anyone tell me if you have any idea that how a legal suit is started in a civil court? For example, I have a friend. Okay, I pay him. He asks me for 5 lakh rupees as a loan. So I give him. He borrows 5 lakh rupees from me, and then he is not returning it. So what will I do? And what is the procedure that I will follow? So I will tell you. First of all, if a client comes to me and he tells me that my friend is not returning 5 lakh rupees, as a as an advocate, the first thing is that we send a legal notice to that concerned person that if you do not return this amount to my client, which is legally recoverable from you, we will file a civil suit against you. And most of the time, if the amount is, a small amount, the other person, nobody wants to go to the court and, file hefty fees for the lawyers, pay hefty fees for the lawyers. So what they do is they settle the matter there and then. But in many cases, like the property dispute, the matters do not settle with a legal notice. Then what you do is, first step is, which starts in the court, is institution of a plaint. You institute a plaint. You will write what the cause of action is and what the relief is there that you are seeking, and you will go before the honorable court and you will file the court fees on the valuation amount. You know what the court fees is, right? So see, if there is a piece of land, for example, it is 200 square meters. So you look at, there is in every state there are circle rates which are there. Every state, and in every state, every district has a set of circle rates wherein government has fixed a particular court fees for that area. So they have fixed a market price. For example, you can download your circle rates if you go through your district court's website, whatever place that you are in. So there they'll have various circle rates. So in circle rate, what you do is you calculate the valuation value of the property, and on that valuation you pay a court. So whenever you institute a plaint, you have to firstly know in which court it will go, which court will have the jurisdiction, what are the parties concerned. Then you should know what your cause of action, when it arose and how is it continuing, and then the prayer, which we also call as relief, and then lastly there is verification. So first step is institution of plaint. Then if the court thinks that there is a valid case, there is a substance in your plaint, and you are, there is, you can be entitled to that cause of action if you prove it, so they will allow your claim. And after that you have to issue notices or summons to the defendants. And when the defendants get those summons that a suit has been instituted against them, in return what they will file, what is, in layman language, the reply of plaint, that is the written statement. So this is what it is saying, that pleading covers plaint and written statement. So if you are the lawyer for, or an advocate for the plaintiff, you will file a plaint on his behalf, and if you are replying from the side of the defendants, you will file a WS or the written statement. And after that there is issue framing, then there is evidence and XYZ, then all the procedural part is there. But for the drafting part, two things are important, plain and WS. Now, why is it necessary? Why can't we go and, or whenever you might have seen movies and everything, you might have seen shows like Criminal Justice, you might have seen shows like Suits, or for that matter, Legally Blonde. There are a lot of shows on that. So there, they do not show you the legal drafting part. They will show you just the arguments which are happening in the court. But I should tell you that arguments hold only 30% of the weightage, the main part. Because see, if I am a judge and I am hearing two people, I will note down the important points. But ultimately, I will refer to their written pleadings, then I would form a judgment, because I would rely on that more, because they are lying in front of. Now coming to the importance, so as I told you, if you have everything in writing, so whenever you also do calculations and everything in your normal life also, you try to write it down. When you write it down, you have a clarity in your mind. So similarly, if there is a written drafted legal document or a conveyancing deed or a plate or a WS which has been written down. So it brings clarity. The rights, liabilities, and obligations are clearly noted down in that document. So also there is legal relationships may it gets a lot of clarity. And lastly, if as I told you, the judge, if they have the written documents in or written plain WS in front of them, they will have it easier to formulate a judgment rather than just basing it on the oral arguments which are there. Now coming to essential, this was just the definition and everything. Now, if you are drafting something, what are the few key points that you should keep in mind while you are making a draft? So, essentials of legal drafting. First is clarity and precision. As I told you, you should know what you are writing and you should have a clarity in your thoughts. So if you are yourself not clear about what relief that you are seeking, if you are not clear about the cause of action, then how will you convince the court to grant you that relief? So you should have a clarity. And precision is, rather than beating about the bush, clearly mention whatever you want, how that cause of action arose. So you might have heard there are 2 points or two things. I don't know what years you are in. If you are in first year, then this. If you are in first year and whatever some of the points that I'm speaking, you do not understand those legal concepts, kindly ask me whenever, and you can stop me and ask me there and then, rather than jotting it down and it will then just create problems in the later point when we will discuss the drafts. So now we will talk about clarity and precision we have done. So you have two things you might have heard, facta probenda and fracta probentia. So basically here what we write is the facta probentia. So whatever the facts which are material facts, they are only mentioned in the pleading. Do not mention immaterial facts or evidences in your drafts. So I will give you an example in the later half when I would be doing the rules of pleading. But do not, if you are claiming recovery of money, do not write I have checks stated this, or I have receipts. You do not have to go into the evidence, because evidence is a different stage of a civil trial, a civil suit. It does not come in the drafting. Second is brevity without losing substance. As I said, you do not go and write unnecessary material. Write only things which are relevant facts in proving your cause of action. Then comes legal accuracy. Now, whatever you are writing should be complying with the existing laws. Whatever you are writing, that should not be something which is illegal or which is not allowed in laws, or which has been disagreed to by any judge in any statutory law or in any case law that might have come on any leading judgment. So that should be legally accurate. It should not be, not complying with the laws which are there. Then there should be a logical arrangement. See, if I am claiming that my client wants a divorce from someone, so from the date of marriage, I will go step by step. So I'll start with the date of marriage. If they had kids, then when the first problem arose, if it is an adultery, the first instance. So I'll write it in a chronological manner rather than jumbling up the dates. I will try to maintain a chronology. Now avoid ambiguity. So wherever your words are creating a nature of doubt or confusion, try to not use such terms which create double meanings, which makes your draft very ambiguous. Then there should be consistency. If I am asking for the relief on the ground for the relief of divorce on the ground of cruelty, then my entire divorce petition should show cruelty. In the middle, I cannot come and jumble up it with desertion. There should be a consistency in my entire divorce petition or whatever draft that you are making. Then coming to the formal language, I cannot use some emotional expressions or some terms which are informal. You should try to maintain that formal language there, because obviously you are presenting it before the honorable court. So there needs to be a element of formal language in your draft. Then lastly, standard forms. Now there are a lot of standard forms that there would be minor differences in a plane that you would see in a district court in Dehradun or a plane that you would see in a district court in Delhi. There can be minor differences, but the basic structure of the draft remains the same. Like you start with the title of the court, then the case number, then the title of the parties, then the title of the suit. So this remains the same. Thoda bahut little differences can be there, but the major chunk or the standard form of your plain written statement, divorce petition, XYZ, anticipatory bail, it remains the same. So you have a leading case which I have mentioned, Bachchan Nahar
Sorry to
versus.
interrupt, ma'am. Ma'am, the
Yes.
screen is not visible.
Okay. One second. Oh, I think it got turned off. Okay, can you explain in both the languages? Since see, I am unable to see the messages because I thought the screen is visible. So if you have any doubt, you can just turn on your mics and you can say whatever the doubt is. So yeah, from now I would try to explain it in Hindi also. Like firstly, I'll explain it in English, and whatever the necessary part is, I'll translate it in Hindi as well. Now coming to the next part, which talks about conveyancing. So, as I again told you, this is the basic of what conveyancing is. So, conveyancing actually means that you are drafting a deed or an instrument wherein you are transferring the immovable rights, or basically the property rights, from one person to another. It can be either in exchange of consideration, or if it is a gift deed, it can be without consideration also. But conveyancing basically means you're transferring an interest in the immovable property from one party to other. So there are a lot of conveyancing deeds, but what we use normally and a lot in your district courts or in your day-to-day life are, first is a sale deed. If there is a sale or agreement to sell of a property, then you transfer the ownership through a consideration, which is the sale price. So sale deed is that. Gift deed is when you are voluntarily transferring a piece of property or anything to other person without consideration. Third is a lease deed, wherein you are giving the right or to possess that property to the other person. But lease has a time limit. I can give a lease if I have a building and I am giving that building to Reliance for 10 years. So the duration of my lease is 10 years. I can give them for 100 years. And at times I'm giving it for 10 years, then there is a renewal. So you might have studied. It can be for 1 year also, then it can be renewed in a number of ways. So lease deed has entirely the everything that what is the duration of the lease, what are the terms that you're placing there for renewal, what is the price which has been paid. So everything you mentioned in the lease deed. Then there is mortgage deed. So mortgage deed means that you are giving a particular, you're giving a person or keeping a piece of property as a mortgage, and in return you are taking some loan from that person. So that piece of property which you are putting it as a mortgage is the security for that loan. And lastly, it is power of attorney, which is actually I'm authorizing someone to act on my behalf. So again, I told you power of attorneys are of two types. One is a general power of attorney. See, if I am have a business here, and I all of a sudden I also open a branch of my business in US, and I shift to US. Here, I give the power of attorney to my sister to look into the affairs and look after the cases which are there of the company, or in general other legal affairs of the company. That is a general power of attorney. But if there is a woman who shifts to US and she leaves her matrimonial home in Delhi, now the husband in Delhi files a case for divorce on the grounds of desertion. So इसमें क्या होता है? What happens is that woman cannot come time and again to India for appearing in the divorce petition. So what she will do is she will appoint someone as her attorney holder by giving a special power of attorney. Special means specially for the purpose of a particular case. तो अभी मैं आपको एक बार हिंदी में भी समझा देती हूँ. जनरल पावर ऑफ अटॉर्नी होता है कि मैं जनरली अगर अपनी सारी पावर किसी को दे देती हूँ कि आप मेरी पूरी कंपनी के अफेयर्स को लुक आफ्टर करिए, तो वो आपकी जनरल हो गई. आप सारी पावर दे रहे हो किसी को आपके बिहाफ पे एक्ट करने की. स्पेशल हो गई कि मैं किसी पर्टिकुलर केस के लिए या किसी पर्टिकुलर पर्पस के लिए, मीटिंग के लिए, एक पर्टिकुलर वाक्या जिसे हम कहते हैं, उसके लिए मैं किसी को कुछ दे रही हूँ अपने बिहाफ में एक्ट करने की पावर. दैट इज स्पेशल. फॉर्मेट इनका सेम ही रहता है, बस जहां पर हम पावर ट्रांसफर करते हैं वहां पर हम वी विल मेंशन दैट व्हाट इज द पर्पस ऑफ द पावर ऑफ अटॉर्नी एंड व्हाट टाइप ऑफ अटॉर्नी इट इज. Now coming to essentials of a conveyancing deed. So आपका basically conveyancing deed में आपका court का नाम नहीं होता है. There is no name of the court which is mentioned because you register it in the registrar's office. So it starts with the name of the parties. For example, let us take the simplest of the conveyance deed, which is the sale deed. So I will start it with the name of the seller, then the buyer. I'll introduce them like like Mr. This, son of this, resident of this, hereinafter referred as the seller. And then the second party, Mr. Son of this, resident of this, hereinafter referred as buyer. So you have to write the entire detail, not just the name, their father's name, if she's a woman, her husband's name, and then lastly, if the person is a minor, can you directly transfer a property in the name of a minor? Can a minor be a part of any contract? Anyone? Can anyone answer this? अगर कोई माइनर है बिलो 18 इयर्स, क्या उसको आप डायरेक्टली कोई सेल कर सकते हो प्रॉपर्टी?
No, ma'am.
No, because you might have studied in your contract law that all the contracts to the minor are void. So what you do is if I am giving a gift to my brother who is a minor, so I will firstly write my name, I am the donor, and my brother will be the donee. So in his place I will write, for example, his name is Parth. So I will write Mr. Parth, son of this, legally represented by. So whoever is the legal guardian, that person would execute that deed on his behalf. Because I can not, although I cannot execute a sale deed to him, but I can gift him a property. I can write his name in my will. Only the sale is not allowed because it is a contract. Rest, they are not contracts. So whenever a conveyancing deed has a name of the minor, you will also write the name of his legal guardian. because they would only execute the property on his behalf, and they would only look after the property till the time he does not become a major person, till the time he does not acquire the age of 18 years. Then comes the recital. So whatever the history of the transaction is, whatever from where you have brought. If I am transferring a property, obviously I might have also bought it from someone, or I might have also got it through succession. I might have acquired it from some source. So I will put that in recital. Then the operative part. Operative part has whatever your sale consideration is. There are times when the person transfers the full amount at one go. There are times where they make part payments. There are times where they give some advance, and after some months they give some then part payments are done. So everything, whatever the arrangements have been made between the parties, that comes in the operative part. Then you have covenants or warranties. So which talks about the rights and obligations of the party. For example, if there is a rent agreement, so what do you think can be the rights and obligations of the person who is executing the tenant? See, if as a tenant my right would be that I should have an undisturbed possession, that the landowner should not interfere with my possession, and my obligation to the owner would be that I will maintain the dignity of the building, the infrastructure. I will not try to sabotage it. So all this would be there as my obligation. So all these rights and obligation. My obligation would also be to pay the electricity bill from time to time, to maintain the condition of the electric wires and whatever the fittings, AC, whatever furnishing I have got with the property. I have to maintain that in a form which I have to maintain it in a form, and I should not do anything to sabotage it. So this would be my obligation towards the landowner. So all these arrangements, basically these are arrangements only which are made between the parties. So these should be there in a conveyancing deed. Then there is habendum clause. So now, if I am the landowner and I am giving only one room of my property as to in the tenancy to a tenant, so I would write that to what extent I am transferring my land to that tenant. So all the extent of the transfer is also mentioned, which is called the habendum clause. And lastly, there is testimonium and execution. ये आपका, this is there in every document, any legal draft that you do. You have to write the signatures, attestations, and registration. So you have to put the signatures of the landowner and the tenant. Then you have to attest it through a legal people who are there who attest the documents. You might be going to the courts and you might have seen that there are people who attest the documents. You have to get them attested. And lastly, you have to go to the registrar's office and register all the deeds that you have. Because you might have heard that unregistered legal documents do not hold the legal sanctity before the court. Most of them, they are not. Now, for the matter of sale deed, recent there was a ruling of the Honorable Supreme Court. Merely having a sale deed also does not entitle you to the ownership of that property. You need to prove possession, and you need to prove that you have been residing in that property or you have been owning that property for a number of years. So this is why it is very important that whatever deeds that you execute, you should try to register them before the registrar in your various districts wherein you are residing or wherever the property is located. Now coming to the basic part, which is the most important part for any lawyer. See, conveyancing, there are few lawyers who would do conveyancing, because if you are a full-fledged practicing lawyer, you mostly go and do civil suits and everything, or you either, if you choose criminal side, then you will fight trials, you will file anticipatory bails, you'll file bails and everything. So conveyancing is not that sparingly used, it is not that rampantly used, but pleadings is very important, तो यहाँ से आप थोड़ा ध्यान से देखना. Now coming to pleadings. So pleadings is basically there in the civil procedure code. Order 6 talks about pleadings. Order 7 talks about how the plaint is drafted. Order 8 talks about how a WS is drafted. So हम start करेंगे order 6 से, because plaint and WS क्या है ये दोनों? Basically they are a part of the pleading. So order 6 rule 1 basically tells you that pleading means plaint or written statement. So pleading covers plaint as well as the written statement. Now what is the objective of filing a pleading? If I do not file a written pleading, then how will I inform the other party of what my claim is? See, for a dispute to be decided, you need to put out what your claim is, and the other person needs to defend himself. And then only there would be an adjudication. एक पार्टी अपना क्लेम रखेगी, दूसरा अपना डिफेंस रखेगी, तभी कोर्ट बीच में एक फैसला सुनाएगा. So basically pleading का purpose is to inform the other party that whatever claim or whatever prayer or relief I am seeking before the court, and what is the basis of that relief. और डिफेंस मतलब जो दूसरी पार्टी है वो लिखेगी, वो उसे डिनाई करेगी whatever my claims are. So that is why it is very essential to have your pleadings filed with brevity and precision. Then आपको दूसरा होता है, जैसे I told you, after your WS is filed, your issues are framed. Issues are the key points on which the court adjudicates. So if you have filed the pleadings correctly, on the basis of them only the issues are framed. Also, then if you file pleading, then you prevent the surprise to opposite party. You might have heard that this is a principle of natural justice, that no one should go unheard. मुझे कोई कब सुनेगा? तब सुनेगा ना जब मेरे को पता होगा कि मेरे अगेंस्ट क्या केस हो रखा है. If I do not know that my neighbor has filed a case of injunction, if there is a common path between our houses and he has filed a case of injunction stopping me from using that path, मुझे पता ही नहीं है ऐसा केस चल रहा है, so I cannot defend myself. And if I am not able to defend myself, if my side is not heard, then how can the court decide? So pleading के through both the parties, they put their claims out before the court and argue over their claims by producing substantive evidences, ताकि क्या है, कोर्ट एक fair decision पे आपका आ सके. Now coming to essentials of a good pleading. As I said, a pleading should contain only material facts. आपको law लिखने की जरूरत नहीं है. See, criminal side, जब हम criminal, एक आपको मैं दो चीजें कराऊंगी criminal में, basic आपका एक FIR, एक anticipatory bail and one we would do or FIR, bail, anticipatory bail and a criminal complaint. So उसमें there you can use a bit of law in proving your case. But when it comes to civil law, you do not have to mention law that under section 13 which talks about 13(1)(a) which talks about cruelty. You do not have to write that. You directly have to write that the petitioner was treating the respondent with cruelty, therefore they are entitled to divorce. You have just to mention the material facts. Law आपको कहीं पे mention नहीं करना है. They should be concise, as I have been harping on this same string. Concise होना बहुत जरूरी है आपका. Evidence should not be included क्योंकि आपका evidence का stage, it is altogether a different stage which is in the later part of the suit. Then again they should be in chronological order. And when you talk about a written statement, in written statement you have to deny everything that the plaintiff has written in his plaint. आप जैसे plaint, you know, every document that you legally draft, वो आपका numbering होती है 1 2 3 4 5 6. So you have to one by one consider point number 1, then deny it and give the reason for denial. Take point 2 of the plaint, then deny it in your. आप अगर कुछ भी, if you leave any point and you do not deny it, that means you have admitted it. तो ये आपको थोड़ा भी confusing लगेगा जब हम इसको properly करेंगे अपने draft में. When we will see the drafts, then you will get a clarity, because theory as I told you, this is not a theoretical subject. You need to have a practical idea as well. Now, then again, you should have a consistency. If I am writing that there has been cruelty, my evidence cannot show that there has been adultery. They should also show that there has been cruelty. आपका consistency should be maintained throughout the trial. Now coming to the next part, which talks about order 6. अभी हमने एक brief आपका एक थोड़ा brief idea लिया था. Now, as I told you, order 6 needs to be done in detail. And today I want you to go, and आपका पास most of you might be having a bare act, the civil procedure code. Even if you don't have it, आप अपना इसमें online देख सकते हैं. Now coming to order 6, which talks about pleadings. And ये मैं आपको एक examples के साथ इसमें बताऊंगी. Now coming to rule 1, if you talk about definition of pleading, ये हम कर चुके हैं. So इसमें हमारा basic आपका सब आता है, जो सब कहते हैं plain and written statement. आपके जो affidavits, petitions के extra चीजें इसमें include नहीं होती. Only plain and written statement, they are included in the pleadings. See, if for example, as I told you, that if a plaintiff is filing a suit for recovery of money, if a plaintiff is saying that the defendant has taken 5 lakh rupees from me as loan and he is filing for a suit for recovery of those 5 lakh rupees, so the reply which the defendant would be filing, wherein he would deny that he has not taken 5 lakh rupees or he has already paid that amount, that would be called the written statement. ये दोनों आपका they form the part of a pleading. Rule 2, pleading to state material facts. तो आपका the facta probenta, which is the material fact, they have to be mentioned, not the facta probentia. Probentia आपका होता है, देखो आपके दो होते हैं. Whenever you have facts, they are divided into two parts. Evidence law में you will study this. First is facta probenta, which are material facts. Material, as the name suggests, it is material to the cause of action, material for your suit. They are important for your suit. And facta probentia are those facts which are not that important, however, they are important in proving material facts. For example, if my material fact is that the defendant had borrowed 5 lakh rupees from me on 20th January to 2025. Facta probentia would be how he had borrowed, the checks that I have, the knowledge, if there is any email or any acknowledgement which has been done. So that is facta probentia. So basic आपको facta probenta लिखना है पहले. कई जगह पे आपको अगर उसको प्रूव करने के लिए थोड़ा बहुत प्रोबेंशिया लिखना पड़े, यू कैन राइट इट, पर मेन आपको जो चीज लिखनी है वो आपको फैक्टा प्रोबेंटा लिखना है. आपको मैं एग्जांपल के साथ बताती हूँ. एज यू कैन सी ऑन द स्क्रीन, द डिफेंडेंट बोरोड 2 lakh on 5th January 2023 and failed to repay. This is a material fact. You cannot write that the defendant was a dishonest man and has a criminal background, because this is immaterial. Even though it is an evidence or if it is a formation of his character that you are writing here, but it is immaterial and you do not have to write such statements in your civil suits. Now coming to form of pleading. Now if you have CPC with you in your home, or if you download it, so once you see the end of the CPC, the last part, like your constitution, there are schedules. Now here also there are appendix. So the appendix A of CPC has a lot of forms. Those forms are basically brief guidelines about various things. So form 1 talks about recovery of money. तो ये आपका basically एक draft आपको हल्के हल्के से they have given it to you, that once you are filing a suit for recovery of money, it should have this draft. If you are filing a suit for recovery of possession of immovable property, this form is there. However, this is just a broad skeleton. You have to mention the facts, you have to mention everything depending on the facts and circumstances of your own case. This is not a hard and fast rule, but this is a general guideline, because for a new fresher who is there, there is no one to guide them. CPC has properly instituted these forms wherein you can take a reference from them and draft your pleadings. Now coming to rule 4. details. But when you are claiming that there has been fraud, misrepresentation, undue influence, I cannot just vaguely write that the defendant committed fraud on you. So this is a very vague statement. I have to write that on 2nd June 2021, defendant fraudulently induced plaintiff to sign sale deed by showing forged paper. So I have to write the entire detail on how the fraud, how the misrepresentation, how the undue influence was committed by the defendant. Now it is very important here. Uh, Recently, I am also teaching drafting to my students in law school. So basically, people try to initially for the first two paragraphs of their pleading, they will be writing plaintiff and defendant. Later, they'll come to proverbs, he, she, it, they. Try to avoid that. Try to use the words defendant and plaintiff. Also, try to avoid using names of those people because you have already disclosed their names in the title of the parties. You do not have to write, for example, if Ravi is the plaintiff. So later on, wherever you are writing that Ravi has committed that Ravi has given money to this person, instead of writing that Ravi, you will write that the plaintiff had given or had executed a sale deed or had executed a mortgage deed or had paid a check of this. So try to replace the name of the parties and the proverbs with the plaintiff and the defendant. So that makes your plaint more presentable and more formal. Now coming to the rule 5. So these rules are very important. Even if you do not remember it, by heart, line by line, you should know them as a formula, as a rule while drafting. See, if you are giving your CPC exam, then so you'll have to remember them by heart, rule 1, 2, 3, 4, 5, 6, 7, 8 in a chronological order. But while you are drafting, you should know what the rule is and then draft it. You should have it in the back of your head when you are drafting. You do not have to cite them because that is there as in you are using those rules while you are making a draft. So they should be there at the back of your head. Now again, if the court is not, rule 5 says further and better particulars. So in scenarios where court is not justified or where the court thinks that your pleadings are unclear, they can ask the parties to amend their pleadings and bring clarity. For example, if the plaintiff has written only one thing, that the defendant caused loss due to negligence. So court might have this doubt that how the negligence was there, they have not disclosed it. So they can ask that tell us when, where, how the negligence had happened. So the plaintiff then has to disclose that. So it is very important that whenever particulars are required, you should supply the same to the court. Condition precedent. So basically, if there is a condition which needs to be fulfilled, for example, if you are filing a case against an insurance company, so if there is some condition which had to be fulfilled before filing of the suit, so you will write that all conditions precedent to filing. Precedent means succeeding means after the happening of an event. Preceding means before the filing of the suit. So you, wherever it is pertinent, that in many suits, for example, when you file a a consumer complaint, it is always important that first you are sending a notice to the seller that there has been a defect in your product, that there has been a defect in your service. You are intimating them. So then when you file a consumer complaint, this is a condition precedent that yes, all the condition precedent that a legal notice was sent to the other party, to the seller, before institution of this consumer complaint. So wherever a condition precedent needs to be satisfied in any form of pleading, you have to mention that in your pleading. Now coming to departure. So all, as I said, there should be no inconsistency. Your pleadings must be consistent throughout. They should have a consistent relief that is being claimed throughout. Now, denial of the contract. See, if there is a suit for specific performance of contract or for a breach of contract wherein you are claiming damages, so you must specify that there was a contract, that contract was legal and the performance has been done. So, for example, defendant denies executing loan agreement dated 1st March 2022. Defendant, uh, in this, the first statement, what is the first statement? First statement is saying that defendant is denying that there was no contract or loan agreement which was made by that defendant. And read the second statement and now tell me a difference between the two. The defendant admits agreement but denies it is enforceable for want of consideration. So what is the difference between the two agreements or the two statements? Can anyone explain? See, in the first statement, what the defendant is doing, he is saying that I did not execute any loan agreement with this plaintiff on this date. In the second statement, he is saying, yes, I agree that I had executed a loan agreement, but then since he did not pay the consideration for the same, that is not enforceable. So here he is not, in the first statement he is denying altogether that there was a loan, that there was no loan agreement between me and the plaintiff. In the second he is saying yes, हमने उन्हें साइन किया था पर उसने मुझे कंसिडरेशन नहीं दिया, इसीलिए इट इज नॉट इन्फोर्सेबल. तो ये आपको क्लियरली लिखना है कि आप क्या बोल रहे हो. दैट आर यू सेइंग दैट द पर्टिकुलर, अपना जो भी आपका रिलीफ होगा, you should be very particular that what you are denying. Either you are denying the existence of the loan agreement or you are denying the enforceability. तो दोनों अलग अलग चीज है. एक्सिस्टेंस मतलब मैंने और प्लेंटिफ ने कोई लोन अग्रीमेंट साइन ही नहीं किया, और इन्फोर्सेबिलिटी मतलब हमने साइन किया पर कोई ना कोई उसमें कोई इलीगैलिटी आ गई जिसकी वजह से वो इन्फोर्सेबल नहीं है. दोनों को आपको स्पेसिफिकली अलग अलग लिखना पड़ेगा, क्योंकि अगर आप, मैं ये लिख दूं मैंने साइन करा है, पर मैं अगर पहली वाली लाइन लिख दूं क्या हो जाएगा, आई वुड बी लाइंग बिफोर द कोर्ट. सो आई शुड specifically write what I am admitting and what I am denying before the court. Now coming to rule 9, which talks about effect of document to be stated. So now again, you do not have to write the entire effect. For example, if I am executing a lease deed, then I do not have to write the entire effect of the document, only the material effect. Whatever the, for example, I do not have to write what the lease deed was, what the condition was, what was the consideration which was paid. Instead of reproducing the entire lease deed, I can just write that by lease deed dated this, defendant agreed to pay 15,000 monthly rent. I do not have to write the duration. Whatever is required for the purpose of my plate, only those details I will extract from my document and state it. Not the entire facts and the story of the document, just the material facts are to be extracted and written in your pleading. Now coming to malice, knowledge, etc. For example, I am saying that the defendant, had a knowledge that the child was a minor, and yet he, signed an agreement with the same. So instead of writing that the defendant acted maliciously, I will write that the defendant knew that the child was a minor, yet he executed a sale agreement with the minor. So you do not have to write such terms wherein you are alleging something on his character or his intention, but you have to prove that how he has acted maliciously. मतलब आप ऐसे डायरेक्टली नहीं लिखोगे कि उसने मेरे साथ फ्रॉड करा या उसका इंटेंशन खराब था. यू हैव टू राइट कैसे उसने मेरे साथ फ्रॉड करा, इंस्टेड ऑफ डायरेक्टली एलिजिंग कि उसने मेरे साथ फ्रॉड करा. Now coming to notice. So at times, as I told you, you need to send notices and you might have communicated your need to the other party for recovery of money, for recovery of possession, और उन्होंने उस पर कोई action नहीं लिया. So you will write whenever you party, you have to mention the details of all the notices which have been sent in your plate. Then implied contract. So at times you might have studied contract, and there are few contracts which are implied also. Some are explicitly done by paying a consideration, some are implied, which happen by, delivering something, which happen by performance of some part of the contract. So if the contract is implied, you have to mention how it is implied and how it has been performed. For example, by accepting delivery of goods and making part payment, defendant impliedly contracted to pay balance. So you will write how exactly the implied contract was executed between the parties. Now coming to rule 13, which talks about presumptions of law. You only have to talk about material facts, not places where presumptions of law are there. You do not have to plead them. You know that there is a presumption of law in evidence that if a child is born within 280 days of the marriage, he is considered to be a legitimate child of the father. In हिंदी I would explain to you. आपने एविडेंस में सुना होगा कि if there is a child और वो मैरिज के 280 डेज के अंदर बॉर्न होता है, तो हम मान लेते हैं, प्रिज्यूम कर लेता है कोर्ट कि वो फादर का लेजिटिमेट चाइल्ड है. तो अगर आप ये चीज अपनी प्लेंट में या हिंदू मैरिज एक्ट में आप पेटिशन में डाल रहे हो कि वो चाइल्ड, दैट चाइल्ड इज द legitimate child, you do not have to prove it, because this is already presumed by the court that if a child is born within 280 days of the marriage, that child is considered to be the legitimate child of the father. So jahan par bhi, wherever there are presumptions of laws, for example, you might have also heard that if a woman dies within 7 years of marriage, court presumes that the death is caused due to dowry death. So all these presumptions, you do not have to write them in your pleading because they are already presumed by the courts. Now lastly, pleadings have to be signed. So once you are done with your relief, first you start with the plaintiff's description, then you come to the cause of action, then a prayer पे आते हो, and lastly you have verification, and after verification the party, firstly the plaintiff signs the plaint and then the lawyer of the plaintiff signs the plaint. कई बार हम उसे लिखते हैं counsel for plaintiff करके you sign it. Sometimes you write advocate for plaintiff or this करके. There are a lot of ways to write it. So lastly, the pleadings have to be signed by both the parties. If it is a written statement, then defendant and the lawyer for the defendant will sign it. Now coming to the next part, verification. It is very important that verification has to be there. Verification means if I am signing, if I am the plaintiff and I am signing the verification, I am verifying that I have read the entire plaint and it is true to best of my knowledge and on my way. So basically ये क्यों होता है, आपका जो आपका plaintiff है वो अश्योर कर रहा है कि सिर्फ मेरे लॉयर ने अपने आप से नहीं बनाई है, मैंने भी I have gone through each and every point of this plaint and I am verifying it. Now coming to 16, 17 and 18, ये आपका इम्पोर्टेंट नहीं है, बट मैं आपको इसका एक ओवरव्यू दे देती हूँ कि आपका क्योंकि ड्राफ्टिंग का पार्ट नहीं है, बट एट टाइम्स अगर कोर्ट को लगता है देयर इज समथिंग wherein you have written some unnecessary details या आपने किसी के कैरेक्टर पे कुछ scandalous लिखा है, they might ask you to strike out such pleadings. For example, that you have written that the defendant is drunkard and womanizer, and जैसे डिवोर्स केसेस में तो फिर भी आपका थोड़ा रेलेवेंस रखता है, but in civil cases it is irrelevant. So they might ask you to strike down such pleadings if you have used such scandalous and unnecessary words. Now coming to 17, amendment of pleadings. Now basically amendment of pleadings is there wherein in the near future, if the court feels that आपका there is some relief which is there, new relief has come, or if you might have done some sort of clerical errors in your claim. For example, मेरे को 5 lakh rupees recover करने थे and I by mistake I typed 50,000 and later I realized you cannot, if see I have already filed my claim and instead of 5 lakh I have written 50,000. oppose it or allow it. And then if they oppose it, court will hear both the parties, and court thinks that this is necessary for the interest of justice, they will allow it. तो आपका अमेंडमेंट जो होता है बेसिकली आपका बहुत रेयरली अलाउ होता है, ओनली व्हेन देयर इज अ ग्रेव इनजस्टिस व्हिच माइट हैपन टू द parties. Now last order is rule 18. If the court orders that you can amend the pleading and you do not do it within 15 days, then you lose your right to amend. Now coming to amendment of pleadings, ये हमें इतना detail में we do not have to do it. So tomorrow we will start with drafting of a legal notice. Now if you have any idea, so I would love that any one of you could draft a legal notice tomorrow and present it. I will also tell you, but agar aapko you have an idea, you might have done internships, you can show some drafts that you have done already there, so that we can share it here. But however, tomorrow our plan of action will be that firstly we will see how a legal notice is drafted, then we will study order 7, and then we will see a draft, a sample draft of a plate. And then on Monday we will draft a written statement. So see, it is only a 1 hour class, so and it becomes very tough to draft a plate in 1 hour. So that is why I'm saying I'll give you some question. You can draft it at your home when you're free, and then you can either ask, you have doubts, or I can ask one of you to just present it in a 5 minute. Like for 5 minutes we can have general discussions on the draft that we are doing. So for today's class, if you have any doubt or any suggestions, you can let me know right now. Okay, so tomorrow we will start with a legal notice, that how do we send legal notices to people. See, when you will pass your 5 year or 3 year law, this is the basic thing that you should know, because any person, any neighbor, any family member can come to you and they can ask you that this person is bothering me, this person is not paying back my amount, it is this amount that I've given them, this person has taken possession of my land. So basic thing that you should know, court to baad mein jate hain, basic thing that you should know is you should know how to draft a legal notice. So tomorrow we will start with legal notice. If you do not have any doubt, I will take your leave. Okay, thank you so much.
Thank you so much, ma'am.